Good afternoon, ladies and gentlemen. Can you all please put down your mobiles and your electronic instruments? We appreciate that this is the last session of the day, commonly called the graveyard slot, but comfort yourselves that this will be by some distance the best panel of the day. And I'm going to start by introducing my fellow panelists, and nothing will be understated in this panel. My name is Stephen Baker. I'm the senior partner of Baker and Partners in Jersey in the Channel Islands, and I specialize in asset recovery and unraveling offshore structures. To my right, immediate right, is Stefan Gray, who is an forensic auditor based in Trinidad and Tobago. He is an extremely experienced professional in the field of offshore finance, and particularly in relation to political corruption. He has some pretty special, if not unique, experience in that he spent the last few years as a consultant to the Guyana State Asset Recovery Agency. So he was intimately involved in the establishment of the legislation and also the operation of that agency. And he is presently, through the UN ODC, an advisor to the Attorney General of Ethiopia. He told me in graphic terms about his last trip to Ethiopia and how much he enjoyed the food and the conditions there. And has told me that he's hoping to do much of his work remotely. So I don't understand why that is, but if you want to speak to him afterwards, he'll tell you in grotesque detail. He was a much bigger man when I last saw him, I should say that. He established the Caribbean Institute of Forensic Accountants, CIFA, and it's in his capacity in that regard that he's here today. To Stefan's right sits Jack DeCliver. He's managing partner of Baker DeCliver in Washington, D.C., a firm which looks at the United States as just offshore. So United States offshore, you should think when you look at Jack. He was a 20-year veteran in the Department of Justice, a very senior official in the asset recovery and money laundering section. He's been involved in almost all of the big criminal and civil forfeiture asset recovery claims in the United States in the last 20 years. He headed up the Department of Justice delegation to FATF for a decade. To my left sits Gonzalo Zeballos, who I anticipate will be well known to all of you. He is one of the world's leading asset recovery lawyers. I told him I was going to say that. You can decide today amongst you whether he is the leading asset recovery in the world, depending upon his performance and also upon the questions and contribution from members of the audience. He's litigating at present in over 15 jurisdictions, both civil law jurisdictions and common law jurisdictions. And it's the Madoff case for which he's most renowned presently. So that's the panel. What we propose to focus on this afternoon largely is the interaction between civil asset recovery and criminal investigations. And all of us on this panel are very regularly involved both with criminal investigators and with civil asset recovery. You hear horror stories at times about conflict between criminal prosecutors, criminal investigators, and liquidators and other civil asset recovery specialists. We're hoping to talk rather more about when it works and how it should work, though we're hugely interested to engage with you in any horror stories that you have that you want to talk with us. We're going to look at its value recovery now. And Ed has invented the term value recovery for this conference, so that in 10 years' time he can say, I invented the term value recovery 10 years ago, which is now common parlance in this asset recovery world. But we're going to look at both commercial victims of fraud and sovereign victims of fraud. What differences there are, well, we could talk about that for days on end, but we're going to touch on both. And I'm going to start by running through a case study, a case which is ongoing at the moment, so it's anonymized, and we welcome questions or contributions from you during the presentation, during the case study. If you've got something to say, just put your hand up, say it. As Ed says, we don't want speeches and the like, but please feel free to participate. So, let me briefly describe a case in which I hope you get a sense of how, at least on this panel, we're working together with criminal prosecutors. There's a case ongoing in a jurisdiction in South America, and a foreigner was charged with a criminal offense. There was a freezing order made over his assets by that jurisdiction in criminal proceedings. The assets, where there was value, were held through an offshore trust and company structure, the sort of structure you'll all, I anticipate, be familiar with. The authorities in the South American country sent an MLAT to the offshore island seeking a freezing order over the trust and company structure and money held in bank accounts by that structure. And that freezing order was made by the court offshore. And if I inadvertently reveal the names of the countries, just forget them, please. It's Chatham House, right? The South American court has very recently ruled that it has no jurisdiction over the foreigner. I don't pretend to understand the basis of that, but that's the ruling that it's made. That's on appeal, but a consequence of that ruling is that the criminal freezing order in the South American country will fall away. That means that once that information is transmitted through channels, the diplomatic channels to the offshore island, then its criminal freezing order will be set aside. So, what to do? We act for the liquidator of some British Virgin Island companies against which we've got judgment, and we want to get our hands on the assets which are held in the offshore accounts. There are all sorts of issues about tracing the proceeds into the trust. There are all sorts of issues about solvency of the people that paid the money into the trust and company structures. I guess there's issues about extraterritorial reach and setting aside transactions and reversing transactions made in the offshore island. What are we all going to do? Because the offshore island faces the problem that if the criminal freezing order is lifted, on the face of it the money can move. There are grounds to suspect that the money is the proceeds of crime, and it'll be subject to substantial international criticism if the money moves. What are the options? Well, there's an appeal in Brazil against the order. There's an appeal. I did it. I did it. In the South Americans, there's only the offshore island to come, and then you've got it, right? It's not mine, I can tell you that. There's an appeal going on in South America.
Not Brazil.
Not Brazil. There's an option is for there to be a private injunction against the assets in the offshore island. There are issues with that. There are tracing issues. There are solvency issues. The offshore island also has civil forfeiture laws. So just as the United States has civil forfeiture laws, I'm not sure you call them exactly that, but you have them, so too does this offshore island. And also, very unusually, in my experience anyway, it has the ability for the victim to join as a party to the civil forfeiture proceedings. So we've got options of supporting the Attorney General of the offshore island in a civil forfeiture, bringing a civil injunction and civil proceedings, or I suppose we have the injunction of, we have the option of encouraging the offshore island to bring criminal proceedings itself and to try and to prosecute somebody or something and confiscate it. So to get the ball rolling, what we're doing is working with the Attorney General of this offshore island. We had personal contacts there. We saw them, we spoke to them, we explored with them what they would find most useful, and those discussions are ongoing. But what it looks like we'll do is move down the civil forfeiture route, that there'll be an injunction which will freeze those assets over civil forfeiture, and then we'll join as victims and try and recover the assets that way. We'll also use local criminal laws to try and freeze the assets by way of something which is fairly unusual on some of the offshore islands, namely where a policeman refuses to consent to assets being moved. And in some of the offshore islands, as many of you will know, if you want to avoid being prosecuted for a money laundering offence, you need consent from a police officer to be sure you won't be prosecuted. And so we can freeze assets in a very simple, informal, and some people would say grossly unfair way, but we can do it. So that's an example of what we have in mind when we say we're going to explore how investigators, prosecutors, and civil private lawyers can work together. And I don't know whether anybody's got any questions which come from that summary, but if not, I'll move on to ask Stefan questions. Stefan, what I've described is using civil forfeiture in an offshore island to recover value in a corruption case. Your experience is of state asset recovery agencies. So can you tell the audience something of the strengths of the agencies that you've worked with and the weaknesses?
Right, well, what you have now going on is a response to the last part of United Nations Pillar of Corruption, Section 5, which I believe is the asset recovery. So you now have countries taking over or trying to implement their own asset recovery agencies, especially the third world countries. It started with Guyana in the Caribbean 2 years ago, passing their legislation. Trinidad and Tobago has passed their legislation like 2 weeks ago. And then you have in draft something from CARICOM, which will probably represent the entire Caribbean region. And then across to East Africa, you have Ethiopia leading the way. And in draft is Kenya and Senegal to follow, right? So you have the whole heap of third world countries now following suit. The strength of their bills are very strong. They have all the institutional, everything you want on paper that the lawyers will be familiar with and want in terms of MLAT agreements, institutional frameworks, the domestic laws. Some of the tailored asset recovery laws are actually very strong. So for example, the laws give the agencies supernatural law enforcement powers, meaning that they have powers of the police, customs, immigration, the Anti-Corruption Bureau, the tax department, all in one. So you'll think that you have all these powers that, you can go forward positively. But we have discovered some obstacles. One of the main obstacles in response to Stephen's question would be human resources, the capacity. So right now we are battling with the question, internal outfitting, that means the countries outfitting it with their own professionals and so on, versus outsourcing. So far, the internal outfitting has not worked, because if you have the countries now implementing asset recovery for the first time, it means a couple of things. The investigators, the auditors, and the lawyers that they are now hiring within their country have not seen an asset recovery case before. So that is an obstacle. So we are now looking at building a relationship with firms, audit firms, legal firms, and so on. The next weakness would be the gathering of data. Third world countries means that you have these supernatural powers amongst law enforcement across the board, but if you don't have computerization across your public sector, gathering evidence and data is an obstacle. It's time consuming and most times non-existent. So like their registry departments are manual, their tax regime is quite weak. Most corruption investigations, you really need that tax department to be very strong. And in all the Caribbean countries into East Africa, the tax regime is quite weak. So even your source of information has no linkages across the network of law enforcement. The third weakness, Stephen, would be you have to have interagency collaboration within the country, which means your financial intelligence unit will be key, your anti-corruption bureau will be key, your tax department, as I said, will be key. But if you look across those countries, you realize that the prosecution for their corruption bureau, tax departments, and their financial intelligence unit is very low. In some cases, non-existent. All right? So those are some of the key weaknesses that we have discovered thus far.
Thank you, Stefan. I want to move to you, Gonzalo, if I can, in the first instance. Let's look at commercial fraud, not just sovereign fraud on sovereigns. How frequently do you find in your practice you working together with criminal investigators overseas?
Well, it's pretty standard in pretty much every case I work on. Is this thing working? It's pretty standard in most of the cases I work on for us to have to look abroad, I think, as it is for most of the people in this room, to have to look abroad for recovery of assets. And when you do so, a little bit of what you have to do is suspend your own experiences, as in my case, as an American lawyer, and move away from the assumption that things are always done abroad in the same way that they're done here in the United States. Whereas in the U.S., working, if you're aware that there's a grand jury investigation on a target of yours, you probably wouldn't try to get involved, or you couldn't get involved in that actual investigation. In a lot of civil law jurisdictions, that opportunity is actually available to you when you learn that there's a criminal investigation taking place. The question is, how do you get involved in those procedures? There's a number of different ways that you can do it. One of which is, if somebody's already initiated a criminal investigation, you can become what's called a partie civile to that process. It's a remarkable procedure because it entails all of the discovery tools that you're used to in the United States, the ability to demand documents, the ability to interview witnesses, the ability to set a marker on a civil claim that's going to follow the criminal prosecution, and the ability to cooperate with the investigating magistrate by saying who you think the witnesses should be, what documents you think they should be looking for, and how they should generally proceed their investigation. One of the remarkable things about this process is that it can be an extremely friendly and symbiotic relationship between the investigating magistrate and the foreign lawyer. As is the case with a lot of ministries of justice and departments of justice around the world, they're understaffed, they're under-resourced. When you show up and you say, look, I'd like to participate in this, and we've already done substantial investigation that we can add to your file, they're generally very welcoming and happy to have you participate in the process. It's extremely important to maintain a very strong and positive relationship with the people in that department, and it brings you to an area where a rule that I think is critical to follow, that every lawyer should follow, which is, as you get involved with this, you'll see that there are lots of things you can do and lots of things you can ask for, and just because you can do something doesn't mean you should, and it becomes very easy to abuse that process and try to overly insert yourself into the investigatory mechanisms that the investigating magistrate is implementing. But done properly, it can be an absolute fountain of information, and the early stages of a case, that's really what it's all about, is getting your hands around as much information as you possibly can.
Gonzalo, my experience of partie civile is mainly where the victim makes a criminal complaint, and so he or she or the country or the company starts the criminal investigation by going to the authorities in a civil law jurisdiction often, makes the complaint, and then chooses the right time to apply to be partie civile. Are there other ways to do it other than be the complainant in your experience, and what's the benefit and pros and cons of that?
Well, there are some jurisdictions where you're allowed to participate as what's called a victim or as a complainant. So in some civil law jurisdictions in particular, you don't actually have to initiate the criminal complaint or assert a criminal violation on the part of the defending party. You simply have to state that you have suffered damage or harm as a result of the criminal acts of the person on the other side of the case. This is a huge advantage on a number of levels, one of which is the defendant against whom you're claiming money may be a civil target to you. So if you're in a bankruptcy proceeding, or it could be a third party against whom you're trying to get information that's not necessarily where the link to you is somewhat more tenuous. As an American lawyer, and I think as most lawyers do, you always have to be cautious of the ethical prohibition against leveraging the threat of criminal prosecution to advance a civil proceeding. The advantage of proceeding as a civil party in a jurisdiction is that it gives you a fair amount of protection from any criticism on that front, because you haven't initiated the criminal investigation. The criminal investigation is already out there, and you're simply stepping in as a victim and saying, I'd like to play a role in this because I have rights that may be lost if I don't.
And the material which is generated during the course of the criminal investigation, which you get to see as a partie civile, how do you use that in, say, civil proceedings in the United States?
That's another very difficult issue, because the documents and witness interviews that you see in most civil law jurisdictions must be maintained confidential, can't be taken out of the jurisdiction until that proceeding is complete. So there's two things that you can do, one of which is you can seek leave from the court, from the foreign court, in some cases from the investigating magistrate, leave to use those documents. I will tell you that in my experience, they're reluctant to do so, so sometimes it becomes a waiting game. We've also come up with some creative solutions on how to do that. We have one case where we asked the investigating magistrate if they would produce the documents to us, and they said they could only do so under color of law, so we asked him if he would accept a subpoena from the U.S. courts to do so. And we initiated a letter of request against the Ministry of Justice. Now, this is one of these things that fell right along the edge of that line of just because you can do something, we weren't sure that we should, because you do have to go into a district court judge and say, I want you to issue a subpoena essentially in your name against the Ministry of Justice of another jurisdiction. And it's not something that they do lightly. So we had actually arranged a meeting with the Ministry of Justice, asked if they would be willing to accept it, and then when they said yes, we asked if they would be willing to put it in the paper, willing to allow us to put it in our papers that we met with them. And then after we developed an even better relationship, asked if they wouldn't mind affirmatively asserting that they would accept and not oppose the letter of request, which to our surprise, they agreed to. If that had failed at any step along the way, we wouldn't have filed a letter of request, and ultimately in that case, for reasons that I don't need to go into, we didn't file it, but we would have been very comfortable doing so under those circumstances. A lot of times you just have to ask when you come up with a solution like that.
Okay, that's hugely interesting. So a letter of request seeking a subpoena on a foreign criminal investigating authority. That's the idea, right? I know we've got some foreign lawyers in the audience. Stefan, you're from the wonderful jurisdiction of France. Could Stefan have the microphone, please? Thank you. Stefan, how do you think your jurisdiction would react to such a request? That's one question. And the second question is, how do you go about getting the criminal investigators material for use in a civil claim here in the United States?
Can I ask a question to Gonzalo? Were you speaking about France by any chance?
I wasn't not speaking about France.
Anyway, I thought, I mean, what you're describing, what Gonzalo was describing is perfectly accurate. I must say, well done for the innovative thinking of going the Ministry of Justice route. This could work. I mean, I think it would be easier to get the permission from the investigating judge or the prosecutor in charge of the case. But as you say, they can be reluctant. They want to protect the investigation secrecy. They think they don't like, they don't like being accused of being influenced by the partie civile. So sometimes you have, well done for the creativity. I hope it was not against my client that you were going after, because I know we were against each other in those days.
If it was, I would have said Brazil. What's interesting is, creative solutions are great, but you shouldn't employ a creative solution just for the sake of employing a creative solution. We had run through the route of asking all of the traditional roads, even going to the point of looking at the MLAT in France, which has a very weird provision in it, which I think is erroneous, which says, has a listing of the people who can take advantage of an MLAT, and it's the standard prosecutors, et cetera, and then it says trustees in bankruptcy. So we went to our French lawyers and we said, look, this says trustees in bankruptcy, so we're going to do an MLAT request. And we went pretty far down the road until we were convinced, and they said, this is clearly not what's intended. It's never going to succeed. It's a waste of time. So, I'm a big advocate of following the easiest route, path of least resistance. Sometimes you can be too creative for your own good.
So, Stefan, do I take from what you said that the French investigating magistrates and the like would be open to a request to disclose material to the victim of a fraud for use in foreign civil proceedings? Or have I not read that correctly?
This is not a legal issue, Steve. It will depend from one investigating judge to the other, basically. And it's discretionary. So I think that if we're mentioning the Madoff case, you will get some traction with an investigating judge who will understand that the victim factor, right? That is there to help. Some other times, if the case is not as important, there will be reluctance. So I think at the end of the day, I think that when you have an investigating judge and you are representing victims, you have to push your case. You have to push your case. The judge doesn't want to be accused of being overly influenced by one of the parties, for instance. So that's the balance here. But you have to push your case. You have to be creative. You have to, I think you're on the right side when you're representing a victim claiming for that information. And you know that in civil law countries, you don't have discovery tools, so you really need the criminal system to get the information. So I think there's a point to be made here, too. And sometimes you can, often you get it, not always.
And Yves, from Switzerland, when you represent a lot of partie civile, right? That's something that you do. How have you found the Swiss courts' reactions to request to disclose material for use in foreign civil proceedings?
To use documents outside the proceedings. So the fight is sometimes about when you get access to the document, but normally, unless there are clear signs of abuse by the partie civile, and then the prosecutor may issue an order prohibiting that party from using those documents in certain proceedings or sharing them with third parties who would not have otherwise access to the documents. The basic thing is that once you have the documents, you can do whatever you want with them. Normally, you shouldn't share them with third parties the circumventing their lack of standing in the case. So normally you should use them only for your own client's advantage, but not for that of third parties. That would be the limiting factor.
So, I mean, I anticipate that most of us here know the answer to what I'm going to say anyway, but if there are people here thinking that there's no point asking for something to happen in Switzerland because it's not going to be disclosed because it's a secrecy jurisdiction and they just won't cooperate, is that a fair or unfair analysis of your jurisdiction?
No, it is a very unfair description. Again, it may depend also on certain cultural aspects. You will, for example, find in Geneva prosecutors who are much more friendly to victims of fraud and will take genuine steps to favor the access to the evidence so that it can be used immediately in other jurisdictions. At the federal level, which has jurisdiction for certain crimes, a more formalistic approach will be taken, and the access to the evidence may take place at a later stage, and you will actually have to wait for the suspect to be examined at least once before you have access to the evidence. But it very much depends on the objectives that you seek, and normally you will be able to convince the prosecutor in charge of the case to give you early access to the evidence if you show that you need steps to be taken, or you can request that prosecutor to seek those steps to be taken through mutual assistance in another jurisdiction to preserve either evidence or assets.
Keith, you've got a point. Can the microphone go to Keith, please?
It's not entirely on point, but it's related, and I wouldn't want anybody to think that this is customary Anglo-Saxon, anti-European or anti-Swiss invective in a post-Brexit world. But I do suggest the common law is present that if you interfere in any way, even passing through Switzerland, where I was recently banned for driving for 4 months for having been only 28 kilometers per hour over the speed limit and fined 1,200 Swiss francs, you do it. Now that's a true story. You do it. I had to tell my insurers yesterday, but that's by the way.
Can they enforce the judgment, Keith?
Well, and actually, when I read the small print, it is enforceable across jurisdictions. So you have a criminal in your midst. But what I wanted to share, and this is a true Chatham House Rules story, but it does, I think, apocryphally perhaps, reflect just how difficult it is dealing with the civil law jurisdictions for common law lawyers. We were acting last year, we settled the case shortly before the trial, for a Saudi national claimant in a substantial case in the DIFC in Dubai, alleging negligence against a professional services company. It was settled, so I won't go into the detail. And our client, for various reasons, particularly in the current climate, wasn't entirely enthusiastic about going to Dubai and giving evidence there live in person as a claimant. And we'd set up, with the permission of the DIFC court, a video link by order on the basis that he would give his evidence from a hotel in Genève. And I was on my way there for that purpose a couple of weeks after the incident I'm about to describe. Sitting having dinner with a good friend in Genève and telling him about this, he said, well, you do realize you're committing a criminal offense. And I said, I'm sorry, what do you mean? He said, well, the Swiss blocking statute. And I said, well, that's obviously nonsense because he's the claimant. He's not being compelled. It's his case. He is voluntarily giving evidence in a major damages claim that he has and that he's brought of his own volition. It doesn't matter, Swiss blocking statute. And we made specific application to the Swiss federal authorities in Bern for the purposes of approval to enable him to avail himself of his ordinary civil rights for this purpose, and it was rejected. And I'm not unrelated, obviously, to the later settlement of the case, but had to be very creative, particularly because the only way we could guarantee he'd be able to give evidence was to go to La France. But of course, he might there have been at risk of quite serious difficulties through Interpol. So, as I said, So the point of the story, beware of civil jurisdiction. It's very risky, as I know to my own cost.
I have to say, Keith, picking up on that, I'm too a criminal. I spent 3 or 4 days in Geneva committing the offence that you've described, blissfully unaware of anything to do with a Swiss blocking statute. But that was over 15 years ago, and I've learned the errors of my way since, and I'm hoping that the offence is statute barred now. Anyway, the Anglo-Saxons have been pointing the finger at the civil law systems and seeing what can we get from the civil law systems. Let's focus on the Anglo-Saxon systems for a while. And so can we get our hands on material generated in criminal investigations in common law countries? So Jonathan, can I ask you this question? If Gonzalo wanted some material which the Serious Fraud Office had obtained from, say, London banks for use in a criminal case, a civil case, look at use in a civil case in the United States, how's the SFO going to respond?
When we discussed this before, you didn't put that question. You put a slightly different question to me, which I can answer.
But you answered the one I thought you answered. I just asked you the one I thought you answered when I asked you the question last time. Okay. Answer whatever question you want, Jonathan. I'll answer my own question in a moment.
Okay. And he's in the US, and I think for reasons that I sort of, that effectively becomes a sort of Norwich Farm. For reasons that I discussed in the first panel, I think that's seriously problematic.
I understand. I understand. But in theory, in the right circumstances, you can get disclosure of criminal proceedings for use in civil proceedings in England, and then there's this issue which you've identified. I have to agree with Martin Kenny. Fairly astonishing analysis of your statute, which we need the Court of Appeal to sort out. Okay. Well, if I can just briefly touch on the Jersey position, I think you'd be very foolish to try and have a Jersey court, order the Attorney General or the Jersey Police to disclose material which had generated in the criminal proceedings for use in civil proceedings abroad. That doesn't mean, I think, that you'd be wrong at law. I think you could win at law, but I think you'd cause so much ill will by doing it that it's a bad idea to do it, and that there exists a very broad jurisdiction under the Norwich Pharmacal disclosure rules, third-party disclosure rules, to allow you to obtain information generated in a criminal proceeding in the little offshore island that I live in for use in civil proceedings in the United States or elsewhere. So we've talked about some small offshore places. We've talked about Switzerland. We've talked about Jersey and Bahamas and England, which will become even more offshore once Brexit goes through. Let's move to the world's biggest offshore center in the United States. So Jack, I'm going to pose a general question to you. How does somebody who's representing a civil plaintiff obtain material generated in a criminal investigation in the United States? And if there are problems, how does he look to get around that problem?
Well, initially, they certainly won't get access to any grand jury materials. What happens before the grand jury will stay secret. In particular, there are a variety of reasons that primarily there may be evidence in there that may implicate other people who aren't charged. And so there are some exceptions to when grand jury material can be disclosed, but generally speaking, for use in a civil litigation isn't it. I think one of the things that you can do, certainly if the case is over, is make FOIA requests for some information. If you want to look at reports of investigation or 302s if it's FBI or any of these forms, you might be able to get some of it. It's going to be heavily redacted, and so it might not be super useful. Not to mention FOIA requests take way too much time. And generally speaking, I think if you're seeking that for use in a civil case, it's going to go in the bottom of a stack and it'll never happen. I think what was probably more useful is, there may be a criminal complaint that's pre-indictment, that's unsealed. And that may actually give you a good roadmap on where to go. So you're just going to have to reconstruct the evidence. One of the thoughts that came to mind is oftentimes in an indictment, there'll be a whole list of assets that at least, generally the rule is as a prosecutor, you list all the assets you know about, whether or not they're the property of the defendant, hoping it is the property of the defendant, and that'll give you a roadmap again of where to go, what to ask for. But generally speaking, the problem that you have for at least U.S. civil litigation, this can only be done post-filing of your complaint. So you can't really go fishing in advance. However, if it's for foreign litigation, as we've heard about 1782, and everybody knows, that's anticipated, then you probably could use that and use 1782 to sort of, so you have a roadmap, so you're not flying blind.
And this may be a really stupid question, and forgive me if it is. When do matters really start to become public in United States criminal proceedings? So the indictment's unsealed. When do you hear things about rocket dockets and all sorts of stuff, which I think that's probably civil claims. But when can you actually see things in the United States?
For example, Eastern District of Virginia, the rocket docket truly is in criminal cases, and it can move very quickly. But I think, certainly when you're looking at asset recovery and those kind of issues, you're too late. I mean, as soon as the indictment's unsealed, that property is moving quickly. So your hope is that some of the criminal process, either directly or indirectly, ties up some of the assets, and you're going to follow up quickly. So I don't really, the unsealing of the indictment, well, you better move quickly. Same with the criminal complaint. If sometimes there is no indictment. Sometimes the criminal complaint is unsealed after they arrest somebody, and then again, you have to move quickly, because if you're looking about, trying to put yourself in a position. Now, let's assume you've been retained by the victims before any of this happens, because the victims, for whatever reason, don't have a lot of faith in law enforcement taking their claims seriously. And that sometimes happens. Certainly in U.S. cases, it's a one-way street, right? You interview the victims, then you don't tell them a damn thing about what you're up to. And they can get really frustrated about that. And so, yeah, it all depends.
Well, there's two aspects to asset recovery, isn't there? There's the freezing the assets in the first place, where you need to get them frozen as fast as possible, right? Where often the criminal authorities are fantastic at freezing things very early, and then there's proving your case afterwards. So the asset recovery involves two aspects, doesn't it? So let's assume the assets have been frozen by, well, it doesn't matter how, but let's say it was by the criminal authorities. When, in terms of proving the case, assume it's going to go to trial, are you most likely to be able to get your hands on the good trial evidence that the criminal prosecutors are using?
Well, one, if there's a trial and it's presented, then it's public information, so you've got that for you. So, actually, one point that I'd like to make that now recently jumped in my head is not too long ago, litigants were demanding and successfully obtained the mutual legal assistance requests that were going back and forth in a major case. And that obviously, unfortunately, this was a criminal defendant doing that, trying to say, oh, they lied and blah, 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 and the restraints were illegal and all of that, which of course didn't work. But DOJ was ordered to turn that information over, even though, it really is a bad, it's an unpublished opinion, that was probably about a year ago. So that's one. I think if a victim, you're going to be way more sympathetic there, and they'll be likely in that situation. Although, technically speaking, victims don't have the right to interfere in criminal cases. One argument I would make is there actually is a provision in Title 18 that requires the prosecutors and law enforcement agents to let victims know what the heck is going on. Unfortunately, most prosecutors don't know the provision exists, but you representing a victim might remind them of their obligations.
Well, you've preempted my next question to you, because in the UK, the Serious Fraud Office say that they will tell victims where they found assets. For instance, if they found bank accounts, they say that they will tell victims. If you went to the Department of Justice and said, look, we represent victims, you must have found out where the assets have gone by now, tell us where they are, what's the response going to be, in your experience?
Basically, yeah, they're going to say go fish. They're not going to give you that. Like, no.
This is why I describe the United States as offshore, you understand. It's a secrecy jurisdiction.
Unlike Switzerland.
Who's disappeared, he's so secretive. The blocking. Absolutely. Can I, Jack, sorry, Gonzalo, can I just ask you this? And then again, this might seem a silly suggestion. It's never stopped me before. If you're looking at bringing proceedings abroad, for the moment, let's stick with civil proceedings. And so you're going to issue proceedings in the High Court of England and Wales. Well, that's what you're thinking about. We know from what you've said that we have the 1782 powers to order disclosure of material held by somebody in relevant district in the United States. What about trying to use 1782 on the Department of Justice to compel production of their information? What's the US response to that?
Well, it looks like these microphones only have a half-life of 8 hours. So basically, on what Gonzalo was saying, that's a bad idea. You're really, I wouldn't go there. Besides, I'll never be able to have lunch with all my former DOJ colleagues if I suggested that.
It's a closely bound society as well. Not many people, and they have dinner together, and they all know each other. And all right, Gonzalo, have you got anything to add to that?
One quick point. Sometimes you come into a case late, and I think Ed was alluding to this earlier. Sometimes you come into a case and the DOJ, has already formed its investigation. It's already frozen assets, seized assets. But it's important to remember the United States is also a jurisdiction where you have the damages remedies. And just because you've coughed up an asset doesn't mean you still don't have to compensate the victim for the damages caused by your taking of that asset. The criminal complaint or the civil, even better, the civil forfeiture complaints can give you a roadmap to where the assets have gone, whose hands they've passed through. And you have a lot of options for fraud, aiding and abetting fraud, et cetera, standard tort claims that can give you treble damages, breach of fiduciary duty claims, for example, that can follow on, that aren't necessarily traditional asset tracing claims, but they're compensatory damages claims that can help make your clients whole.
That one. Or this one.
Okay, third one is the charm. To follow up, I mean, one of the things is, at least in the criminal cases, you can have both assets forfeiture and restitution above if the bad guy has more money. And restitution, of course, will go to the victims. The other thing is even forfeited assets, just to be sure, will be remitted to victims. The downside of that is it takes such a long time because it's unfortunately a bureaucratic process. I think there are other things that can be done. I think this is a key thing. Like, certainly if you're a jurisdiction abroad, and even if the excuse me 1 second here. Even if the money isn't in the United States, if it passed through the United States, it is worth considering that if the money went to jurisdictions with whom the United States has a relationship, they can civilly unlike the extraterritorial restrictions in some Latin American country that shall remain nameless, but we all know it's Brazil, the U.S. law is the opposite, right? Just a slight connection with the U.S., if that money passed through the U.S., would allow the United States, assuming there are violations of U.S. law, which is an assumption, to then reach out to that money where you might not be able to get to it in your particular cases. Because one of the rising trends is, and this is a big question, is that many countries now passing civil asset forfeiture laws. With that comes the ability to enforce. It's always been a big issue, but it's falling to the wayside. Is okay. The they can enforce your order, but then where does that money go? And that's a problem with victims, because if they don't have the appropriate mechanisms in their asset forfeiture funds, or worse yet, the money just goes into the general treasury and there is no mechanism to pull it out, then you're in a bad situation. So I guess the bottom line there, and this is something we're getting to, is cooperation between private and well, the issue we're discussing between private and state actors is you need to very, very carefully map out every move before you get to checkmate, because otherwise you're going to get derailed early on. And all of these things, and frankly, I mean, I guess one of the answers is you get a lawyer in each jurisdiction. I don't think that's always practical, but you certainly need to look at both the criminal and civil and make sure that the end game gets you where you want to be. But the extraterritorial provisions in U.S. law are really strong for the DOJ side. And there's one that probably none of you know about that I shall not name, but it basically allows the United States, even though the money's abroad in a jurisdiction with whom they have no relationship, is to forfeit that money from the correspondent bank account of that foreign institution. And that's gold. You know, that if you don't have any, you could get a civil judgment, as was discussed on the panel earlier, but if you can't enforce it, then what good is it? Then it's toilet paper, right? So if you can come up with creative solutions by making US DOJ a partner, but again, you need to know how to navigate that and what's required to get that authority and approval, because you need to provide that information to the U.S. authorities.
Thanks, Jack. Stefan, the lawyers on this panel have been looking for shortcuts. They've been looking for the criminal investigators and prosecutors to give us the answers and to give us the evidence. They've said no. They've refused us. What skills do you bring to the party? How do you prove your case through financial investigation in your experience?
In my experience, one of the problems we have with state agencies, recoveries, and financial investigative reports, we have a lot of established firms, I won't call any names, that are doing forensic or financial investigative reports, but they are staying away from confrontation because of their risk management profile and so forth. What do I mean? They tell the story. So for example, you're on a procurement investigation where millions of dollars have been overspent in collusion and procurement fraud and so forth, and you have the firms telling the story, yes, the non-compliance issues, the breaches in the policy procedure, the Procurement Act, but they refuse to quantify the loss. Right? So once you refuse to quantify the loss, and when the report goes to the lawyers, you have this extra process, and I'm sure Stephen will know about this, and Ed, where the lawyers now have a whole list of questions, and it comes like you're doing over the financial investigation because you have not quantified what the loss is. Because once you have the quantification of the loss, then you have options available to you. You have one, if it's a firm or individual, if it's a firm especially, you have tax issues. So that's the tax issues could be a backup in terms of the filing, in terms of the fraud that has occurred. You have fiduciary issues on the directors and so forth. And of course, once you involve the taxpayers' dollars and so on, the lawyers will have an easier job in starting their process. And also, a lot of the financial investigations, you don't have that jump start with regards to identification of assets, because the financial investigators also have to play it safe in terms of how they get their information on where assets are located. So which is the debate between using the formal route and the informal route, right? My experience is the informal route is always king. You give the lawyers what they need. Yes, you may have, you lawyers know what I'm talking about. They have issues in how you attain the information. But guess what? If you have, like 2 weeks ago, we got 5,000 line items of bank payments in East Africa. But we got that covertly, informal, right? Now, after we go through all that data, if there are 15 transactions which are of interest, we then simply just pass it to the lawyers and they do their pretty stuff, file for the disclosure orders. In other words, they have a head start. Instead of you just giving them that blank approach, and they now have to subpoena or try to disclose 5,000 line items of payments. They have a head start in terms of they are going for these 15 transactions, and once the financial institution responds to the disclosure order, that information is now more or less legal. Okay?
I think we need to put this on the panel for next year, Stefan. You can lead the charge on this one. I'm just going to, if you forgive me, move back to 1782. I've got a question for Jack, and I've got a question for Gonzalo. And Jack, I suspect this question is known. The answer is known by almost everybody, apart from me, probably. Can you use 1782 both for criminal and civil complaints abroad or proceedings abroad?
Yes, there's case law on that saying that you can gather that information for potential use in criminal cases abroad. And, for example, in the UK, you as a aggrieved party could initiate criminal proceedings, and so that clearly would be an example of where they could be used. But also, frankly, there's no requirement that any jurisdiction that's doing a criminal case use the treaty. They could actually have an investigating judge go and say, I want an application in a U.S. U.S. venue where evidence or a person of interest is located, and you could use 1782 to get that for that criminal process. This was the tool that the Department of Justice used. They used 1782 up until 2010, when a specific statute was put in place in Title 18 saying this is how you can gather information. And it's a better statute because it doesn't limit you to the jurisdiction where the information is located. It gives you the ability to, from one district, in this case the District of Columbia, to just gather all the information no matter where it's located within the U.S. So it'd be a nice fix to get that in Title 28.
Okay, Gonzalo, if you generate some information for use in proceedings abroad using 1782, and you get a judgment abroad, can you use the 1782 information that you generated in order to enforce the foreign judgment in the United States?
You can. You won't necessarily need to in the enforcement context. What's a little more of a tricky question is, can you use the 1782 process to get specifically to allow you to enforce your judgment, in other words, to find assets against which you're going to enforce the judgment you've already obtained abroad. And surprisingly, there is a split in the courts in the U.S. on that. There are a couple of circuits that have held, despite the extremely liberal interpretation of what proceedings meant, have taken the position that if the proceeding is concluded abroad, there's no proceeding for which you're using discovery under Section 1782. So this jurisdiction, Florida, is a jurisdiction which allows you to get discovery to enforce your foreign judgments. But the lesson to be learned there is that if you think you may have to enforce in the United States, you should be getting that discovery before the conclusion of proceedings, or as early as you possibly can.
We've got a couple of other topics, but I would like to ask, has anybody got any questions that they want to ask following where we've got to so far? We start with the gentleman at the back. Is that John?
Yes.
Yeah. It's very intimidating. You're an intimidating man anyway, John, and there's a light shining in my eyes as well.
My recollection is that 1782 in the criminal context can be used by potential defendants to gather evidence. And if they gather it properly as potential defendants, they can use it for any purpose. Yeah. Before, I mean, if they believe that that there's a prospective criminal charge being brought, they are allowed to seek evidence that would address that.
I'm trying to work out, John, how I could, keeping to my code of ethics, use that information to get disclosure in an asset recovery action.
You would be getting disclosure for the criminal action presumably the asset disclosure materials would be related to that.
Yeah.
For example, if you were accused of stealing money and buying a property in France, and there were French policemen asking questions about it, you could go to a New York bank, if it was relevant, and say, where did the money come from to purchase that? Because it wasn't me. And that would be a perfectly good use of the statute.
Yeah, I'm encouraging us all to think outside of the box through this really interesting point that you've raised. I suppose if you're a foreign politician who's a genuinely good person, who's accused of wrongdoing with a view to him not, well, let's go to Russia for a moment. We've got them tomorrow, haven't we? If you have a Russian opposition leader who's accused falsely of criminal wrongdoing because he's rooting out corruption, perhaps he could get information out of the United States for his defense, which revealed where dollars have held. Ed likes this one. I can see his head.
I agree with it. I think the one qualification is that in the statute it says you can use 1782 to gather information to support a criminal case. Any interested party can do it as long as it's pre-indictment or the equivalent of an indictment. So once the indictment comes down, you can't use it anymore.
We all need to be on a plane to Moscow.
I mean, I think that if we were to try to fill a room with the politicians who are going to use this to try to prove their innocence, it would be a pretty small room. But that said, yeah, they will try. But that said, I mean, there is a person who's running for president, former attorney general, who you met, Steve, in Guatemala, Thelma Aldana, who is absolutely being whitewashed now. And, you know, and she might, for example, use that because there are allegations against her, which pretty much the whole world believes are false, but they're trying to sully her reputation. So it could be used in that regard, or by any defendant.
Anybody else got any questions? Maureen?
An interesting story that might be relevant to people in other jurisdictions. Interesting Canadian perspective that might be relevant to other jurisdictions. A plaintiff was recently criticized by the court for using a 1782 process in a class certification motion. And the judge sort of said, well, there's a process under our rules for you to get that, and you wouldn't have met the test, and it's kind of created a chill on Canadian lawyers utilizing that. So,
Has anybody, sorry, Maureen, go ahead.
Curious to know if that's happened in other jurisdictions, of other people here.
That was my question. Anybody come across foreign courts trying to get involved in the use of 1782 in the US, restrict it?
Well, it's a significant price-fixing class action as well, and that piece of it settled. So now there's this unresolved decision out there that we'll never, we'll see who wants to take that chance and do a 1782 without, trying to get permission first, which is what would have normally happened.
Well, I have had clients in the UK ask me if there's that are afraid of 1782 applications, and one thing I've suggested to them is go to the court up front and ask for an order saying that they will not accept, and directing the parties not to use Section 1782, and ask for an order setting that forth. And so it's very judge specific, and frankly, I'm not even sure I understand the procedure under which you would do that. But I do know that it is not uncommon for judges that don't like that process. And it happens in arbitration all the time that the arbitrators will say up front, no 1782 discovered, no 1782 applications. Once that's done, you're never going to get anything under the statute.
I know there's a couple of other questions, and I'll come to them in a moment. My limited experience of this is we had a trial ongoing in Jersey, and there was a lawyer in New York, quite famous New York lawyer, who I'm not going to name, who we thought was going to give evidence voluntarily, and then for various reasons he refused. And so we instructed Ed's firm to get a 1782 on him during the course of the trial. And Ed pulled all the stops out and tentatively suggested that a letter of request from our judge to the American courts might enable them to do it. And our court refused to issue the letter of request for no good reason whatsoever, other than saying they thought the lawyer should give evidence voluntarily. So it got involved in that sense, but it was pretty much an extempore, off-the-cuff judgment. So I'm really embarrassed to say I've forgotten your first name, but if you... I didn't hear that, so...
Sasha. And the question I have, a lot of the conversation has centered around legal entitlement, but as you just mentioned... Oh, sorry? Oh, sorry. Anyways, a lot of the conversation is centered around legal entitlement, but as you just mentioned, for example, with managing the judges, a lot of this is really beyond legal entitlement. It's about managing the softer skills, about managing relationships, ensuring compliance, making sure shifting politics and not Brazil don't screw up your case. So I'm kind of curious, what would be your biggest suggestions for outside of court tools to maintain those relationships and to potentially, if needed, put some pressure to prevent, let's say, a judge from becoming too strict upon limiting discovery, or to prevent a party from backing out of an agreement to help provide information?
There's a lot of aspects to that question, I think. Shall I chuck this one left, Gonzalo?
I may need you to simplify your question a little bit, because I'm not quite sure I followed everything you were asking.
Apologies. I guess so. Especially, for example, when working, let's say, with that, with the Cayman judicial, not Cayman, but in the Caribbean judicial system that you're describing, that you're working with, that you chose not to name. What would be your best suggestions for kind of out-of-court tools to maintain that relationship and keep pressure on?
I mean, I think you have to be very cautious. I mean, the way you've worded the question, I would be, my answer would say absolutely nothing. I wouldn't take any steps other than professional relationship that we have. You have to be extremely careful. There are very clear lines that you can't cross. Now, I will say, you know, as you cross the line into different modes of dispute resolution, that even your personal interactions with arbitrators, for example, are heavily scrutinized. So it's generally one of mutual respect and professional relationship, but I'm very reluctant to ever go beyond that.
I think, if I understand the question, I think 100% you can't be approaching judges, right? That's just... That's completely off the list of options, and I don't think you were suggesting that. But if what you mean is what steps do you take to make sure you get the best result in the offshore island, which you assumed was Caribbean, but there you go. You need to make personal relationships with the people in the law officers department and the criminal investigations team completely properly. But ideally, if one of your team knows somebody in that team, then you need to get in touch with them, or you need to find somebody who does know them and build a good relationship. It's a very soft, just human skills, building relationships. Dan Wise from the BVI at the back. Okay. Any further questions before we briefly move on to maybe one or two other topics, and I promise you we're going to be finished before the witching hour. Gonzalo, have you come across anything new recently in your experience in terms of fraud, hiding assets, money laundering?
Yeah, the most interesting case I've come up with recently in the last couple of months was I was asked if there would ever be a situation where an arbitrator would be subject to a notification requirement under Section 328 of the Proceeds of Crime Act. And in the course of doing my research on that, Section 328 of the Proceeds of Crime Act requires you, if you become aware of fraudulent acts or either to procure, retain, or transfer proceeds of crime, you have to file a suspicious activity report with the relevant authorities in England. And I was asked if under that provision that an arbitrator would have to file a notification if they became aware of corruption in an arbitration. Kind of an esoteric question, but initially I thought this is an easy question because there's a case, I think it's called Bowman v. Fells, my English colleagues will correct me if I'm wrong, I think that issued around 2005 that said that the attorney-client privilege and access to justice overrides the notification requirement. But looking at the question a little bit more carefully, the problem that you have in arbitration now, and this is a new area, at least to me it was a new area for fraud, is sham arbitration, where you have corporations set up with a contract, a breach, there's a breach of the contract, there's a payment of, say 20 million pounds pursuant to the breach provisions of the contract, or it's a 20 million pound contract. They go to arbitration, they bring in a real arbitrator, and now the arbitrator issues a judgment, an award. The parties maybe reach a settlement and issues his award saying that the parties must pay $20 million, but all it is actually a way of laundering 20 million, or 40 million, whatever, laundering that money so that it's now clean. And under that circumstance, does the arbitrator have a duty to notify? Now, staying away from that, I'm not going to touch that topic here, but I thought it was remarkable that this is a really difficult problem for us in the fraud, asset tracing, and recovery world, because it is very difficult to get behind a confidential arbitration. You're going to have a hard time in most jurisdictions getting access to the arbitrator's materials, thought process, the tools that you need to pierce that proceeding to show that this was a fraudulent transaction and to get that money back. I don't know that I have an answer to any of this because this is very, very new.
I was at a conference last week where a judge from an Eastern European country, which I will not name, had made findings that fictitious loans had been put in place between fictitious companies, so not with a view to laundering the proceeds of corruption, so not using arbitration, but using a court order. They would sue on the loans and actually have a court order with a great stamp and the like. And that was the first time I'd ever come across it in practice. Does anybody have any experience of a fictitious court order or a fictitious arbitration award being used to launder money? No, it's interesting. Has anybody got any experience of Bitcoin being used to defraud? Is anybody instructed in a Bitcoin case? So I've asked questions I wanted to, which have got nothing to do with this panel. Right, we're early. We're 3 minutes early. Has anybody got any points they want to make? Any questions they want to ask? No.
Now you can make a speech, but it has to be 3 minutes or less.
Okay, thank you all. Thank you to Jack, to Stefan, and to Gonzalo, and thank you for listening.